Hello everyone, welcome to podcast 3 on the AAT and merits review. In this podcast we're going to go on to have a look at the decision-making powers of the AAT. So the AAT, being a merits review tribunal, conducts a full de novo hearing. In other words, the decision can be considered afresh. These requirements are set out in section 43 of the Act. In subsection 1, the tribunal may exercise all of the powers and discretions conferred by the enactment on the person who made the decision, and under section 43 1a to c has the power to affirm, vary, set aside and substitute, or set aside and remit the decision back to the original decision maker. The touchstone for the AAT, the requirement is that they step into the shoes of the original decision maker and make the correct or preferable decision. And this is discussed in the Drake cases. There's Drake number 1 and Drake number 2, which we will discuss shortly. In the AAT, because the tribunal is looking at making the correct or preferable decision, there's a requirement to argue a case differently at the AAT as in the court, because you're not addressing specific grounds of judicial review, and the AAT makes a holistic assessment. They can remake the decision because they are part of the executive branch of the government, which the court is not. So the court does not have the power to make a fresh decision on the facts, which can be more limited. Let's have a look at the She and Migration Agents Registration Authority case. In the She case, the AAT reviewed a decision by MARA, the Migration Agents Registration Authority, to cancel She's Migration Agents Registration. So MARA is the key body that registers migration agents and monitors their conduct according to the Code of Conduct. She's MARA registration was cancelled in 2003 after MARA, now known as OMARA, the Office of the MARA, found a significant number of breaches of the Migration Agents Code of Conduct. So under the Code of Conduct, there are certain requirements that must be met by migration agents in order to show they are fit and proper persons to practice and in order to continue practicing. The MARA found that these breaches were made under Section 314 of the Migration Act. MARA made a finding that the agent was not a person of integrity and therefore not a fit and proper person to be providing migration assistance. She then applied to the AAT for review of MARA's decision to cancel his registration and other decisions that had been made by MARA, including a decision not to re-register him. The appellant was granted a stay of MARA's decision, which meant in the meantime he could continue to practice as a migration agent up until the time of his hearing at the AAT. The hearing at the AAT was 2 years later. 2 years later, at the hearing, the AAT found a number of breaches of the Code of Conduct had been made, but concluded that it was not satisfied that he was not a fit and proper person to give immigration assistance. It set aside the cancellation decision and the other decisions that were under review. In this case, the AAT decided that the appellant should be cautioned and certain conditions should be imposed upon his ability to practice as a migration agent. In making this decision, the AAT took into account new evidence that had emerged in that 2-year period after the original decision was made and before the matter came before the AAT. So the issue was it appropriate for the AAT to take into account this fresh evidence that wasn't before the original decision maker? So what is the extent to which the AAT is able to take into account new material? The High Court considered this issue and found the answer was yes. The AAT can consider fresh evidence that has arisen since the decision was made since the original decision was made. The High Court looked at Section 43 of the AAT Act and said that it did not expressly answer this question, but it came down to statutory interpretation. And Justice Kirby set out a number of factors which are there on the slide relevant to this task. So the radical nature of the AAT's powers and purpose, the function of the AAT, the purpose of Section 43, and the nature of the decision under review. So the case confirmed the principle that merits review is conducted at the time of the review and on the latest material available. Because the AAT is empowered to step into the shoes of the original decision maker and remake the decision, they're generally expected to have regard to the best and most current and up-to-date information. So in Xi, the wording of the Act, the Migration Act, was with respect to whether the applicant was presently a fit and proper person. So it was naturally more suitable to take into account the up-to-date information in that case as well. So this is the general rule that the AAT can consider fresh evidence and will be expected to have regard to the most current and up-to-date information. But again, it will depend on the nature of the decision. So for example, Social Security benefit reviews as to whether the applicant met the criteria at the particular time may need to be determined on the basis of the information at that particular time, rather than taking into account new evidence. So in the Pico-Wallsen case, which is authority for taking into account the best and most current information, it was possible to refer to the letter, even though the minister, who was the original decision maker, had not seen that letter. The minister was expected to have constructive knowledge of the letter. So this is the same type of principle, the need to take into account up-to-date and relevant information. However, the limitation on this is that the AAT has no greater powers than the original primary decision maker because it is an appeal body rather than a primary decision maker. So it can't exercise a power that was not engaged or exercised by the primary decision maker in the first place in the relevant decision under review. So they're just reviewing the same decision that was made, even though they're able to take into account new information in doing so. Let's have a look at the role that government policy plays in relation to the AAT's decision-making powers and to what extent the AAT is able to take into account government policy. So a key question here, is the AAT bound by government policy? The AAT merits review and government policy work together, so the AAT is able to take into account considerations of policy because it's part of the executive arm of the government, and there's benefit in the efficiency of following government policy. Is it bound by government policy? It needs to perform an important review function and is not accountable in the way that other government bodies are accountable. So the general rule in relation to the extent to which the AAT can take into account government policy is discussed in Drake number 1 and Drake number 2. Can the AAT merits review interfere with government policy? There's a Drake series of cases, Drake number 1 and Drake number 2. So Drake number 1, Drake was a man who lived in the Northern Territory. He was convicted of growing cannabis. The minister had the power to deport a person convicted of growing cannabis under the Migration Act. The relevant ministerial policy, as on the slide, was that the power should be exercised in the best interests of the Commonwealth, and the set of factors which determine when deportation is in the best interests of the Commonwealth were set out. In that case, the minister applied the policy and decided that Drake should be deported. So the case concerned an appeal to the AAT for merits review of the minister's decision. In Drake number 1, which was the appeal to the AAT, the court confirmed that the AAT exercised administrative and not judicial power. The AAT may have some of the features of a court. For example, the President is a judge of the Federal Court and has some court-like procedures, but this does not transform what is an essentially administrative function into one that is a judicial function. In Drake number 1, it was left to the AAT to determine the part which ministerial policy should play in the decision-making process. So policy can reduce inconsistencies and enhance the fairness and consistency of the decision-making process. On the other hand, policy is not law. The policy must not be inconsistent with the statute, and in every case, the relevant decision-maker must exercise their power according to their statute and can't depart from that in the interest of following policy. So this is also consistent with the view taken in the Green and Daniels case, which has already been considered earlier in this unit. So the question that the AAT must ask is this decision the correct and preferable one on the material currently before the AAT? So the AAT can take government policy into account, but they need to be cautious as well. And in the case it said, it's not desirable to frame any general statement of the precise part which policy should play. So the AAT needs to determine whether it is the correct and preferable decision, taking into account the law, the policy, and the facts. In the second Drake case, Justice Brennan set out some relevant factors in relation to policy and the AAT. So the relevant factors were that the AAT's role is to determine the correct and preferable decision. The AAT is independent and is as free as the minister to apply or not apply that policy, to adopt whatever policy it chooses or no policy at all. The AAT can decide to apply or ignore government policy unless the terms of the statute make clear that the policy must be taken into account. The AAT must not apply unlawful policy, although the AAT should apply lawful policy unless there are cogent reasons not to. So Drake number 2 was when the case was remitted to the AAT for rehearing. In conclusion, policy should be used cautiously and sparingly. So this is to promote consistency and is especially important because it is approved by Parliament. So it should apply lawful policy unless there are cogent reasons not to. In the end, Drake was deported, so it didn't work out well for him. In practice, the AAT almost always does follow government policy, despite the fact there is now far more policy than at the time that the Drake cases were decided. Because merits review can be taken away by Parliament, there is this constant tension in practice. Now, in relation to potential exam questions, when there is a question in relation to the AAT, you should consider whether it involves a question of law which may lead to an appeal from the AAT decision to the Federal Court, which is spelt out specifically in Section 44, subsection 1 of the AAT Act. So there are appeals available from the AAT to the Federal Court. It must be a decision, so it must be a final decision, not merely interim rulings or adjudications. And it must be on a question of law. So a question of law involves the case where there has been an error of law or a legal error, and it can include all the grounds of review, such as natural justice, relevant or irrelevant considerations. It can include unreasonableness or the tribunal misapprehending its functions, as outlined in Comcare and Etheridge. And this is because the AAT appeal under Section 44 is the preferred avenue, because under Section 10, subsection 2B of the ADJR Act, it's required that all avenues of review must be exhausted first. And in an AAT appeal, you need to be aware, if there is an AAT appeal on a question of law, you're not referring to the ADJR Act, but it's a question of law on the basis of access via Section 44 of the AAT Act. In Queensland, we also have a system of merits review set up under the key administrative body in Queensland, the Queensland Civil and Administrative Appeals Tribunal, established by the relevant Act in 2009. The major difference between the QCAT and the AAT is that there is no separation of powers. So QCAT has both primary and review functions. However, in this course, we'll only be considering the review functions. Under Section 3 of the QCAT Act, the same requirement applies as for the AAT, so matters should be dealt with in a way that is accessible, fair, just, economical, informal, and quick. Section 4 also provides a similar requirement as for the AAT. The tribunal's functions include encouraging the early and economic resolution of disputes, including, if appropriate, through ADR. The focus in this course is on appeals and reviews to the AAT rather than to QCAT. However, those provisions are also relevant. In summary, the pros and cons of merits review are outlined on the slide. So tribunals have a very important role in supervising the government. They're more accessible to the public because they're cheaper, and the process may be easier and quicker in terms of access. They review a greater number of decisions than the courts. They may provide a form of review that satisfies the interests of the public in a way that judicial review cannot, by reviewing the merits. And this can have a very positive outcome for applicants if they go to the tribunal and receive a positive decision. It's a fresh decision which may result in a positive outcome. For example, their visa may be granted or their license or permit may be granted, whereas with judicial review, the decision will be remitted back to the original decision maker and may take a very long amount of time before the decision is finally reached, which may still be unfavourable to the applicant. The disadvantages of merits review include that tribunals cannot conclusively determine questions of law. The person aggrieved by a decision of the tribunal may often seek judicial review anyway, so it still may ultimately be a time-consuming process for that person. And the rights of merits review are conferred by Parliament and are not constitutionally protected. So this is a significant limitation on the position of merits review tribunals. Merits review can be taken away or eroded by statute, so it's not always possible for applicants to access merits review as well. And there's also the consideration of whether merits review is an adequate substitute for judicial review. In conclusion, there are a couple of revision questions in relation to merits review and the operation of the AAT. In relation to government policy, there are 4 different options on the slide. We need to consider which is the best answer of the 4. When conducting a merits review, how should the AAT treat government policy? A. In most cases, it must be applied. B. Where it is consistent with the subject matter, scope, and purpose of the legislation, it must be applied. C. It should be considered in the context of the merits of the case. They must consider it as they would other relevant matters. Or D. Unless the policy is unlawful or its application would tend to produce an unjust decision in the circumstances of the particular case, it should be applied. So the best answer here is D. Unless the policy is unlawful or its application would tend to produce an unjust decision in the circumstances of the particular case, it should be applied. And the final question, a question of law appeal under section 44(1) of the AAT Act relies on A. An error of law similar to the grounds usually used for judicial review. B. Any of the grounds defined in section 46 of the AAT Act. C. An interim ruling from the AAT. Or D. Either applicant wishing to appeal. So the best answer in relation to when a question of law appeal can be made out is in relation to A, an error of law similar to the grounds usually used for judicial review. The second one, section 46 of the AAT Act, is fictional. The third one, interim ruling, is incorrect. It must be a final decision. And D, it cannot merely be either applicant wishing to appeal. There must be a legal error, a question of law to be addressed. Okay, that's all for this week on merits review. Thank you everyone for listening to the lecture. I'll speak to you again next week. Thank you.